name is Pietro Sirena, and I am the second vice president of the European Law Institute. I'm truly delighted and honored to moderate the webinar of today on family and succession across borders, during which we will present the principles that have been recently delivered by the European Law Institute at the completion of the research project that has been carried out and conducted by a research team of prominent academics and practitioners and other stakeholders. We will have today the luck and the pleasure to hear from two of the members of the research team that has elaborated on and drafted these principles and carried out a valuable work of really consideration and engaging really in a work on these principles, namely Professor Elena Bargelli. I'm going to introduce them in a few moments, but first I would like to announce their attendance. Professor Elena Bargelli, who has served as co-reporter of the research team I have referred to, and Paul Paltraida, who has also served on the research team as a member of this project team. And of course, I failed what I should have done previously, but I really would like to extend my warmest gratitude and welcome to all the attendees of this online meeting. I'm sure that you are aware with the agenda of today, and therefore you for sure are aware that we are going to open at the end of the first part of the webinar of presentation of the principles. We will have and we will open a Q&A session in which we are going to collect questions and of course to hear interventions from the floor. So I kindly invite you, any of you that wants to chime in with some questions to really make use of the final Q&A session that, as I said, we will have at the end, in the final part, to say, of this meeting. So a few words on the principles, but then I'm going to yield the floor to the two speakers of today, particularly to Professor Elena Bargelli, who for sure can be much more than me, introduce us into the work that they have conducted. It is an instrument of private international law, of course. The methodology that has been used by the research team is truly and highly comparative. It has been based on a comparative analysis of different jurisdictions. I would say it's really impressive when one have a look at the list of the members of the project team, that I mentioned several times, but also of the advisory committee, of the consultative committee, including, I would say, representatives of potentially, if not all, European jurisdictions, but really most of them, and that offered their insights into their own not only um, law and case-made law, but also the practice and the views of the various stakeholders involved. Of course, the substance of we have said that it's family and succession across borders. So again, on the one hand, it's private international law that is here concerned. On the other hand, the substance of the scope of the principles covers family and succession matters across the European countries. And of course, the aim pursued at first by the project is to identify the legal uncertainties and to map, so to speak, to figure out the potential innovations that can be introduced. And that to some extent have emerged from the analysis that has been conducted by the research team. So it's a set of recommendations to lawmakers potentially because they can be used, of course, as model rules, but not only. They are aimed as well at practitioners for sure, notaries public, as well as counsel to the parties involved in this. Family and succession matters across borders, particularly attorneys representing clients at court, and other stakeholders, of course. And the aim or the core aim that is pursued by the project is ensuring that particularly extrajudicial procedures in these matters are applied more and more consistently in a coherent way. And that, of course, they are based on, or they, I mean, are aimed at the respect of the rights of the parties involved, and that, of course, achieve a high degree of effectiveness of the protection of these rights. It's 7 principles, and this is, I believe, a plus because it's really the members of the research team have been able to condense to encapsulate such a large subject into 7 principles, and basically they offer really an updated roadmap for private international law to be reshaped and in order to reflect contemporary legal realities. Of course, it's also, or it conveys a strong commitment to upholding the core values of the European laws, of European law as a framework itself, of course, of the European Union, even though these principles to some extent look also beyond the Union and envisage to encompass Europe as such, even beyond the 27 members, European countries that are member of the Union. So, as we said, this is, I think, a wonderful opportunity. Well, first, on the side of the institute, which to a certain extent I represent here, it's a wonderful opportunity to disseminate these principles. It's one of the achievements that we carry out in the institutional activities of the European Law Institute and disseminations, of course, as one of the goals that we pursue as a way that we are committed to being engaged in order to really participate in the public debate on and in the discussion on the further developments of European law in the different, of course, fields and from the different angles that can be encompassed. But for all the participants, for all the attendees of this webinar, this is as well a wonderful opportunity to engage directly with the authors, or well, with two of them at least of these principles. And of course, we are also very interested in hearing the opinions and the views that are going to be voiced from the floor. So, as I said, and I can see that also a message has been dropped into the chat box. So, again, I kindly encourage you to well participate in the Q&A session and in the discussion, of course, that is going to take place before the closing remarks. With that said, let me spend a few words in order to introduce the two co-authors of the principles that are today in attendance. It's also the opportunity for me to extend the sincerest gratitude of the Institute for their commitment. It has been really remarkable for the contribution that they have offered to this project that I would say is really one of really the main project that we have carried out in the portfolio of our research activity. Elena Bergelli, the first speaker who is going to take the floor, is a professor of private law at the University of Pisa in Italy. Of course, she has been a research fellow at the Max Planck Institute of Hamburg, a visiting fellow at the Institute of Advanced Legal Studies in London, and also at the Yale Law School. And among many other commitments and achievements in her curriculum, she is also a member of the European Center of Tort and Insurance Law. And her areas of interest are focused mainly on contract and consumer law, tort law, family law, of course, and housing law, as well from both a national and a comparative perspective. Paul Partreider, who is the second speaker that we have in attendance today, is a research associate at the Austrian Academy of Sciences in Vienna, which is also home to the European Law Institute, by the way. So we are neighbors, if I can say so. Previously, he worked at the University of Munich and also an international law firm. And after concluding his studies at the University of Innsbruck, Paul was involved in various international research projects. Not only this one for the European Law Institute, I have to say that Paul is really committed and generous enough to have really joined several working groups. And for this, we are grateful to him. As a PhD student, he spent 2 research stays also at the Max Planck Institute in Hamburg. And by the way, he is a member of the Italian bar. My last words, promise, before giving the floor to Professor Bacelli, is that I failed to mention that the leadership, the co-reporters, of course, beyond Professor Bacelli, but as co-reporters of this group, I failed to mention Professor Anatol Dutta from the University of Munich and François Tremosa, a notary public representing therefore together with the academia, a professional environment of stakeholders that are particularly involved in this topic. And with no further ado, at this point, I'm happy to invite Professor Elena Bargelli to take the floor to start the presentation and later on the discussion of the principles. Please, Elena, the floor is yours.
Thank you very much, Mr. Chairman, and thank you to the European Law Institute for this opportunity to disseminate the project. And of course, thank you to all participants for joining us today. I will provide, first of all, of course, I'm speaking here today also on behalf of the other co-reporters of the project, Anatol Dutta and François Tremosa, who have been mentioned by Pietro. I will, in my introduction, I will provide an outline of the background of the project, of its methodology, and its outcomes. That is the European Law Institute's principles on extrajudicial administration of justice in family and succession matters. These principles provide or are aimed to provide a guidance to national and European policymakers concerning issues arising in cases where, next slide, acts in family and succession matters are in at least one member state reserved to courts, but fall in another member state within the competence of other authorities or the parties themselves. It means that the project focuses on a growing phenomenon, which is that of dejudicializing matters which are traditionally reserved to judicial courts and which have been recently shifted to the competence of public authorities, administrative authorities, or notaries or lawyers. The project is based, of course, the dejudicialization is a matter, is a decision falling within the competence of member states. However, in case of cross-border situations, there are issues falling within the realm of Article 81 of the Treaty on the Functioning of the European Union. That is an issue of judicial or non-judicial, in most cases, cooperation between member states arise. Which are the reasons behind a member state's choice to dejudicialize a certain matter, family or succession matter. The main reasons are to be seen in the need to simplify and speed up procedures, strengthen the autonomy of the parties and the consensual resolution of disputes, to mitigate family conflicts, respect privacy, prevent paternalistic interference in private and family life, and ideally to reduce costs of proceedings. Next slide. It has to be underlined that the approach of the project towards this phenomenon, this trend, is quite neutral. In fact, we do not start from the idea that the-judicialization is a good or a bad thing, but we start from observing that principles or a guidance is needed as far as legal consequences of acts in family and succession matters depend on the will of the parties under the substantive law of the member state. In this case, in the case in which the member state has already given relevance to the autonomy of the parties, that member state should consider, for the sake of consistency, shifting competencies from courts to other authorities or the parties themselves. This is the only, suggestion we address to member states, which is founded based on a reason of consistency. Next slide. The principles are based on a comparative analysis of 16 member states. From the comparative analysis we have conducted, we have observed that the main dejudicialized areas are those of dissolution of marital status, allocation of parental responsibility, certificate of succession, authorization, specific tasks, like receiving declarations, opening wills, gathering information on the deceased, and finally, assistance of vulnerable adults and gender reassignment. Next slide. You can see now two slides with a sort of list of member states and the ways they have decided to dejudicialize some family and succession matters. As you can see, the ways the dejudicialization has been conducted vary considerably between member states. In fact, as far as the authorities involved, there are member states which have given the competence to notaries. Others have provided administrative authorities with the competence to issue administrate certain matters. These two slides refer only to the dissolution of marital status, that is divorce, and consequences of divorce, as well as questions of parental responsibility. So we can see a huge variety of authorities involved, notaries, administrative authorities like public prosecutors, mayor or civil officers or registers or court secretary, and so on and so forth. Even the tasks assigned to these authorities vary considerably, as some authorities have the power to examine the substance of the agreement, others simply register the will of the parties or simply receive or register the wills of the parties or uphold and check their wills. A very controversial issue is that of the hearing of the child in case that matters relating or children's rights are dejudicialized. Even the matters which have been dejudicialized in the single member states vary, are quite different. There are, in fact, member states which have decided to dejudicialize only divorce. Others include children's rights. Slide number 7. As regards the authorities involved in the dejudicialization trend, we can see that most authorities deal with consensual matters, which means that their competence is reserved to non-contentious proceedings. However, there are a few cases where extrajudicial authorities are tasked with contentious proceedings. This is, for instance, the case of the Danish Family Agency or the will executors in Sweden or the Danish lawyers delegated by the Ministry of Justice in succession matters. Next slide. Against this background, the objectives, the aims of the ELI principles are clearly that of guiding national and European policy makers. There are, in fact, principles addressed to member states, others addressed to the EU institutions. In general, the aims of the principles is that of enhancing the level of mutual trust between member states, facilitating the cross-border circulation of authentic instruments, agreements, documents, recommending that non-judicial procedures provide for adequate guarantees to all parties involved, and in general, the principles insist on more consistency, simplicity, and clarity of the EU acquis of private international law. Thank you very much for your attention. I don't know if you, Pietro, wants to take the floor again. Otherwise, I will go on with the core principles and will present the first set of core principles.
Thank you, Elena. I maybe in turn ask Paul whether he wants to chime in with any observation.
So far not. I think you can go on with the principles. I will then address certain things during my presentation later on.
Great. So please, Elena, if you want to proceed with the first set of the principles.
Thank you very much. Then I will start presenting the core principle, the core principles number 1, which is the first set of principles, and in particular the principle focusing on minimum standards. Perhaps have you shared, yes, the screen? Yes, that of minimum standards, which is a very important principle in the framework of our project. In the screen, you can see, next slide, in the screen, you can see the text of the principle number 3, which focuses on minimum standards, which means the minimum level of procedural or substantive safeguards that we suggest or recommend to member states. It is important to underline that this principle is indeed addressed to member states. Slide number 2. One of the most difficult tasks of us as projects team was to choose the most adequate terminology. As you can see, the principle refer to authorities without making clear which authority we are referring to. We use also some very apparently generic words like acts or parties participating in the act. As regards the authorities, slide number 3, as regards the authorities involved in the principles, as I have just said in my introduction, the authorities we have found in single member states are quite different and have quite different tasks. There are, in fact, authorities which merely receive and register will declarations and agreements, which are drafted by the parties themselves or by their lawyers. There are authorities tasked with the competence of drafting with declarations and agreements, but also verifying the identity of the parties, their will, and the legal requirements for declarations or agreements in order to ensure that these declarations and agreements produce their effects. Or finally, there are cases in which the authorities have the power to examine the substance of declarations and agreements. Given this huge variety of tasks of the authorities we had to deal with, we have chosen to use the term authority instead of trying to qualify this authority as court or non-court. In fact, these authorities, as I have just said, have quite different nature. Not only they have different tasks, but they have also different natures. Slide number 4. No, I think that I'm not sure whether the slides are the right one. I have lost. Can you hear me? No.
Yes, Elena, we can hear.
Okay.
Sorry, I was muted.
I'm trying to check. Sorry for that.
You are muted.
Elena, at present you're on mute, yeah. Can you please activate your microphone?
Yes, sorry. No, perhaps I sent you the wrong slides because these do not correspond with those I have. I will send you immediately the right ones. Thomas, sorry for that.
In the meantime, while Elena is sending the presentation to Thomas, may I ask Paul
Sorry,
if
perhaps there was
whether if Paul wants to take the floor or if Elena wants to continue.
well, I go on,
Yes.
but I'll send. Okay, then I open again the PowerPoint presentation. Anyway, I will go on. Thomas, if you will receive the slides, the slide I'm talking about is slide number 4. So minimum standards, that is minimum level of procedural or substantive safeguards addressed to member states. Why are we decided to recommend member states to adopt these minimum standards when a single member state decides to dejudicialize a certain matter? The reason is that the judicial activities, proper courts, are of course subject to constitutional safeguards proclaimed by at European level the Charter of Fundamental Rights. It is enough mentioning Article 47 of the European Charter of Fundamental Rights and Article 24 of the Charter concerning the rights of the child, and in particular the child's right to be heard. Conversely, no requirements are set by EU regulations for authorities other than the courts, apart from the need to respect the child's right to be heard, as Articles 39 and 68 of the Brussels IIb regulation, in fact, do. And therefore, the need to adapt judicial standards to non-judicial authorities arise. Which are the minimum standards we recommend to member states? Of course, the first standard is that of impartiality, which is, of course, an incontrovertible requirement not only for judiciaries but also for administrative authorities and notaries that participate in non-judicial acts. In fact, all authorities involved are subject to the law and must apply it impartially and without bias. However, as we can see from the overview of the 16 examined jurisdictions, impartiality of non-judicial authorities seems not to be an issue in any member state we have examined. Slide number 6. Parties' right to express their views. Who are the parties we are referring to? Of course, the parties we are referring to are those required to give their consent, as I have just said, most extrajudicial proceedings are consensual proceedings. In addition, parties possessing the right to express their views are also those who are directly affected by the act. For instance, children below a certain age who are not required to give their consent. The parties' right to express their views is the expression of an effective opportunity to take part in the proceedings, which has to be granted to the parties affected by the act, which means that these parties have a right to be informed about the proceedings and their effects, and that the personal appearance of those parties should be ensured, should be granted as a precondition to effectively check their identities, to better safeguard that the act is based on their genuine will and that their interests are fairly balanced, as I will say in a while. Personal appearance, again, is not an issue in most jurisdictions we have examined. In 15 jurisdictions, it is indeed required. Only one jurisdiction exempts the parties from personal appearance in case of divorce proceedings. Parties' right to express their views includes, of course, the children's right to be heard, although there is no absolute obligation to hear a child, especially where, as in most cases, in most extrajudicial situations, the proceeding is consensual and there is an agreement between the parents. However, in our opinion, the children's right to be heard must be a possibility and must be granted in cases in which the involved authority holds the hearing necessary to ensure the best interest of the child, and therefore this possibility should be granted. This is why we believe that it is advisable to provide extrajudicial authority with the power to examine the substance of the agreement in light of the best interest of the child. This possibility is not granted in any all jurisdictions, in all the jurisdictions we have examined, and in particular France and in Greece, this possibility is quite problematic. Furthermore, we recommend that if the agreement, the parents' agreement, does not pass the test, the authority should refuse its participation in the act and ensure that the best interest of the child is satisfied by summoning and hearing all the parties. As regards the modalities of the hearing, these are, of course, more problematic in extrajudicial contexts. The modalities should be in line with the relevant European and international standards, in particular, a minimum age requirement should be ensured. The authority conducting the hearing should be qualified. For instance, it should be specifically trained. The presence of a qualified non-legal professional might be advisable in certain cases, and an appropriate out-of-court setting should be granted. A further safeguard is the judicial review, which should be in any case granted. This is not clear at national level. The comparative overview we have conducted shows that the ways the judicial review is made is not always quite clear, but the general idea is that if the effects are produced by party autonomy, the parties should have at disposal the substantive remedies such as the annulment of the contract for vices of consent or incapacity of the parties involved, and so on and so forth. If conversely the effects of the act are not produced by the parties, but by the act itself, then an appeal, a kind of appeal should be granted. Finally, we have recommended that member states put in place measures or means to safeguard a genuine will and a fair balance between the interests of the parties involved. This might be made, for instance, by granting by providing the parties with assistance or advice made by qualified professionals, which is not always granted in the jurisdictions we examined. It means that may be effective in safeguarding the genuity of the will of the parties is to grant a reflection period, as, for instance, Italy, Romania, and Lithuania provide. And a further important safeguard is the obligation for the parties to disclose their income and financial assets, which again is not always the case, and which is quite important when the economic consequences of a divorce are at stake. Thank you very much for your attention, and I am very much looking forward to receiving feedback from you.
Thank you so much, and Elena, for your thorough introduction and presentation of the principles. Should I give the floor to Paul? I'm asking him. Yes, please, Paul, go ahead.
So just a second here.
Yeah, we can see your presentation, Paul.
Perfect. I just wanted to really quickly say thank you for having me today. I was very much looking forward to disseminate this project further. I've been working on it together with the project team starting in 2023 through 25, so a couple of years. So it's good to share some of the results that we gathered. The screen is shared, as I've been told. Do you see the full screen version of the presentation?
Yeah, now we can see it. Even though it seems when you scroll it down, it looks a bit weird, I'm afraid. Yeah, but yeah, now it works. Please go
Okay,
ahead.
perfect. I think we're already running a little late, so I will try to focus on the core principles. So to speak, the principles number 4 and principle number 5, which are the principles concerning the cross-border aspects, or which are more focused on the cross-border aspects, which have already been talked about in the beginning. So I'm going to share, or as you can see on the screen, you can see the text of the principles. We're not going to read them together, just so you can follow what I will be talking about. The main point about principle 4, which, as I said, is the first one concentrating on the cross-border aspects of private international law in family and succession matters. In this regard, is that we proposed as a project team to extend the current regimes of jurisdiction also to authorities other than courts, which have been described before, to have them only participate, to have these authorities only participate in an act in family and succession matters if their respective member state has also jurisdiction for that matter. The goal basically was, in this case, to avoid positive and negative conflicts, first of jurisdiction, but also of acts, so to speak. These rules should consequently, in general, apply both to courts, as to do right now, and to other authorities in general. So why is this actually an issue? As you might know, most of the private international law instruments in cross-border family and succession matters provide for definitions of what a court should be for the purposes of that respective instrument. But it still remains unclear to a large extent which acts of these non-judicial authorities, which we're talking about, or even the private parties themselves, are to be regarded as judicial activities in the sense of these definitions. Article 3, paragraph 2 of the succession regulation, for example, states that a court can be any authority other than also courts in the traditional sense, so also legal professionals or notaries, for example, as long as they exercise certain judicial functions. There have been some indications in the case law, of course, as some of you might be familiar with, stating what these judicial activities actually are. A first one might be the Sayuni case, which some might know more from the family or cross-border family law perspective, but it was one of the first cases with regard to the Rome III regulation, which stated that private individuals cannot be regarded as courts. Basically, this decision stated that the Rome III regulation, which governs the rules on applicable law in divorce matters, cannot apply if no state authority is involved in the respective proceedings. And the court went on to say that the concept of court in the Rome III regulation is the same than in the Brussels IIa, and consequently, presumably, also the Brussels IIb regulation, which would basically mean that no private individuals, of course, can be bound by the rules on jurisdiction, even if they carry out certain acts in family and succession matters in their jurisdiction. Another interesting case from Italy from a few years ago, from 2022, also picked or at least slightly touched upon these matters, which is the TB decision of 2022, which stated that, or which held that the divorce enacted by an Italian civil status registrar should circulate according to the Brussels IIa, but also then according to the Brussels IIb regulation, as a decision, meaning that the civil status registrar carried out judicial functions in this matter. Given that the regime on recognition of courts was thus applied in the TB decision, it should also be held, of course, as a consequence that the rules on jurisdiction should be applied as well. And this, just very briefly, seems to be something that is not clear to everybody, or in particular the Italian registrars that we talked about during the project, that according to this TB decision, they might now be actually, or they are actually required to assess their jurisdiction before carrying out a divorce proceeding involving parties of different nationalities before them. There's another case which concerns child custody, but which I will skip now for reasons of time, and delve a little bit into the notion of notaries, which is slightly a bit more relevant, I think, in many cases. We have had an extensive case law in this regard from the European Court of Justice, starting with the Oberle decision, which concerned the granting of a national certificate of succession by a German court. In this case, the Court of Justice basically held that activity, so a court issuing a national certificate of succession in Germany, would qualify actually as a judicial activity for the purposes of the succession regulation, meaning that the German courts could only actually issue these certificates when they had jurisdiction under the succession regulation. When it came to the involvement of notaries then, in the WB and EE case, so cases involving Poland and Lithuania, the court was more reluctant to hold that these notaries, when issuing national certificates, were actually to be qualified as courts for the purposes of the succession regulation as well. So why is this relevant? And why did we propose to introduce this jurisdictional filter? This jurisdictional filter for principle number 4. Well, when the jurisdiction rules only concern the judicial enforcement of acts in family and succession matters, there's a possibility of contradictory results. This can be highlighted, for example, by the EE and WB cases. The succession certificates in Lithuania, so the national ones, and in Poland, have largely the same effects as the German court-issued certificate. The Polish one even exceeds this effect, or the effects of the German certificate. So from a functional approach, it seemed justified to us to extend these rules as well. We put an example in the comments on this principle as well, which was the case of a Turkish national, for example, which resided in Germany but had assets in Poland and Lithuania. In these cases, according to the Oberle decision, only the German courts would have jurisdiction or would have competence to issue the succession certificate under the succession regulation. Nevertheless, given that the notaries in Poland and Lithuania are not bound in their activity by the succession regulation under the current regime, they might be involved by potential heirs as well, which might lead to different results, which is, for example, or a reason for this is, for example, the application of a bilateral treaty between Germany and Turkey. There are many bilateral treaties in succession matters for specific member states, which take precedence according to Article 75 of the succession regulation, while the Polish and Lithuanian notaries might in these cases just apply the general rules. A testator, for example, or as is the case in this example, with a last habitual residence in Germany, and apply German law, and consequently apply also different statutory rules in this regard. If it is an intestate succession, the shares might even be indicated and calculated differently in these cases. This obviously allows also for forum shopping in specific or certain cases, not only in succession matters, but also when it comes to divorce. People might be, under the current regimes, more attracted to go to a easy and simple and especially inexpensive out-of-court procedure, for example, in France or in Italy, without the jurisdictional rules, at least for France, applying. So that is why we propose to extend the current regime to include also acts in family and succession matters which non- or out-of-court authorities participated in. This is already something that can be found in the succession regulation for the issuance of the European Certificate of Succession, for example, under Article 64. We have the extension of the rules of jurisdiction for said certificate. But we propose to make this a general rule. One very last thing on jurisdiction, which also leads me to Principle 5, the extension of effects, is that we also included the possibility under Principle 5 of refusing the extension of effects of a certain act if the authority issuing the act or participating in it did not have jurisdiction under the rules of the European Union instruments. This is something new to the acquis, so something that does not exist so far, or for the most part, let's say. and constitutes a slight discrimination also of acts, of dejudicialized acts in family and succession matters compared to the judicial ones. But we thought it necessary to allow for such an indirect jurisdiction review by the member state of, or by the authorities of the member state of destination, as long as certain of these out-of-court authorities are unfamiliar with checking their own jurisdiction, as is the case, as I mentioned, with the Italian civil status officers. So let's talk about, oh, I see that you've only been seeing the text of the first slide of my presentation. So now we'll come to the, now we'll come to the extension of effects. I put the first two subsections here. You have the text. I highlighted a few words here as well. I mean, we briefly touched upon this already. The basic meaning of subsection 1, which is the central element of this principle, is that act in family and succession matters, which has been issued in one member state, should have the same effects in the member state of destination as far as possible. This, of course, is a quite far-reaching proposal, which is why we introduced certain safeguards and thresholds here as well. Two first requirements are that concern the general scope also of the principle, which is that the act is in one member state in the competence, or falls in one member state within the competences of courts, while in another member state, as for example, the issuing member state, it is a competence of a non-judicial authority. And the second requirement is that the act produces, as to its essential elements at least, the same effects as a court decision in another member state. Should this be the case, then this principle that we proposed extends the effects by operation of law. This is, as is expressly stated, also only justified, however, when the European Union already harmonizes both the rules on jurisdiction and on applicable law for the respective family or succession matter. And this is a general approach which can be found also for the automatic recognition of court decisions in matrimonial and succession matters, for example, and which we basically extended to out-of-court or dejudicialized acts as well. Because we had a lot of discussion both within the project team and during the procedural steps leading to these principles about the terminology used. I mean, we've already touched upon, or Elena already touched upon, the general terms acts or participate in, which you can find definitions of in the comments on these principles. Another example would be this extension of effects. Every one of you that is familiar to private international law knows that generally we speak of recognition or of the acceptance, or the recognition of judicial decisions and the acceptance of authentic instruments. But within the group, we reached the conclusion basically to find a more neutral term, a more functional concept of transposing one legal situation that was shaped in one member state by an act in family and succession matters into another legal system in another member state. Why is that? Currently, it is often not sufficiently clear whether the effects of a certain act derive directly from the will of the parties, or from the agreement of the parties, or from the involvement of the authority. To give you an example, turning again to the Italian divorce, divorce before the mayor, and maybe also touching upon Principle 7, which we can talk in a minute, is that while there is the involvement of an authority which was qualified, according to our comparative research, also wrongly by the Court of Justice, as a review as to the substance of the agreement between the parties. The effects, as was held by the Italian Supreme Court, already derive, so the divorce already derives by the agreement between the parties, not necessarily by the involvement of the parties. And this has consequences on the level of recognition and which methodology to apply here. To make it a little easier for the receiving authorities to understand what was happening and going on in the member state of origin, we proposed also to introduce certain European standardized certificates. Just to be clear, we did not want to introduce certificates with autonomous legal effects. So their basic aim is to record the essential elements and contents of the underlying act in the respective matter in a formalized and understandable way, so that the receiving authority could also trace the proceedings and what was actually going on, and checked, especially in the member state of origin that issued the original act. This is essential, we thought, also to strengthen the mutual trust between member states, so to have something easily understandable without the need to introduce many free field or free text fields, which cause still certain problems with regard to the European certificate of succession. Right. Just so that we have some time for the discussion, I will move on to the third subsection, which concerns the grounds for refusal of the extension of effects. We already said that this is quite far-reaching, the principle, so we added an additional layer of safeguards, which are the grounds of refusal, which can generally be found in all private international law instruments of the European Union. And also in this case, we based the grounds on the acquis, on the existing acquis, except for the last one on jurisdiction. So we basically have the possibility to refuse the extension of effects if the receiving member state considers the act to be contrary to their public policy. I'll open a bracket here. We do not think that this exception should be invoked just on the ground that it is an out-of-court document or act in this case, but it should be able to invoke this exception if the minimum standards that Elena talked about were not respected in the procedure. And number 2 and 3, so letter B and C, basically concern the irreconcilable acts, both from a member state, or both if it concerns a member state or a third state document that might be recognized, so to say, in the member state of destination. Well, the last one concerns the fact that a member state should not necessarily recognize or extend the effects of an act if the issuing authority did not have jurisdiction under the respective rules. So coming to the second part, so principles 6 and 7, very quickly, we're leaving the field of cross-border family and succession law to some extent, at least, and we'll focus on some more general principles here as well. The first one is the preliminary reference principle, which is our number 6. In this case, we proposed basically to extend or open the current quite strict definition of court or tribunal, which exists under Article 267 of the Treaty on the Functioning of the European Union, to allow certain of these non-judicial authorities within the scope of our principles to rely on the preliminary reference mechanism. As you know, these authorities that participate in these acts already apply and need to apply the instruments of the European Union to some extent. So we thought it might be a very useful tool also to clarify certain questions concerning the application and interpretation of the EU acquis beforehand. Also avoiding professional liability for any activity carried out by the parties. Currently, the concept is very strict, so we basically have 3 requirements for an authority to be qualified as a court for the purposes of 267, which is that it has to be established by law, it has to be permanent, meaning it cannot just be some temporary or ad hoc institution, and it has to be independent. So these points are quite unproblematic also when it comes to the respective authorities which are most of the time involved in the matters that we had a look at. But generally, the Court of Justice also requires these bodies to resolve disputes and deliver decisions of a judicial nature, which, according also to our comparative research, is only very seldom the case. So most of these dejudicialized matters, as has already been touched upon, are consensual matters where the party agree on the dissolution of a relationship or the establishment of a certain status, and so on. There are, however, certain cases of the European Court of Justice which adopted a more functional approach. For example, the Brigitte Schlömp case on a Swiss mediation body, which was considered to be a court for 267 because its decision had functionally equivalent effects to a judicial decision. Interestingly enough, and then I will go on to the last principle, I think, is the Al-Bausi case, which was delivered in 2024, in which, for example, also consistent with its approach, the Court of Justice, for example, held that a German court issuing, so a traditional court issuing a European certificate of succession could not use the preliminary reference mechanism because when issuing the certificate, it was not exercising a judicial function. Maybe on the other aspects we can touch upon during the discussion. So the last point, I hope you can see the text of the principle right now.
It's not, yeah, now it's full screen. Thank you.
Sorry. Yeah. The last principle, which concerns, is a very general principle, which is a wish or an aim that we formulated within the group. As you know, the various dejudicialized procedures vary between the different member states. So procedures are very much different, concern various different topics. So we thought it necessary to give some certain guidelines or certain tools to specify certain things within the procedures also for the national legislators. So it seems advisable to provide clear substantive and procedural rules specifically with regard to these dejudicialized procedures. I think it's an aim. Clear rules are something advisable everywhere, but especially here as well. I already mentioned the Italian case where it was not clear from a doctrinal point of view whether the effects of the divorce agreement between the parties derived from the agreement itself or from the involvement of the parties. It had to be determined by the Italian Supreme Court whether the substantive or procedural remedies, so contractual remedies such as certain errors, could be brought forward in the proceedings. Secondly, subsection 2, also to be very quick. The European Union should avoid leaving certain gaps within their instruments. For example, currently under the Rome III regulation, under the divorce regulation or applicable on divorce matters, we have the so-called, or something that is called the Sayuni gap as well, which means that the divorces in which no state authority participated in are not governed by the respective enhanced cooperation that is Rome III, which is something that leads to different solutions within an otherwise harmonized field of the law. The subsection 2 also means that the European Union legislator should take the trend of dejudicializing certain procedures into account more actively, so not to leave certain gaps within the regulation of both jurisdiction and the extension of effects, meaning recognition and acceptance. The last point is the simplification of the existing regimes. Some of you might have read the proposal on the parenthood regulation, which I don't know if it is still being worked on, but still this just highlights the current trend of trying to introduce more and more regimes. In the case of the parenthood regulation, we had 4 different regimes for the recognition or acceptance of certain acts in parenthood matters, which, while being good to have that, to be able to cover all possible acts in the respective matters, also leads to problems in the qualification of these acts. So in practice, it becomes very difficult to, especially to non-experts of private international law, to understand whether or not a certain document or act is to be qualified as a decision, an agreement with binding effects, without binding effects, or simply as an authentic deed or private document. And with this, I close so that we have a few minutes of discussion maybe, or feedback or input. Thank you very much.
Yeah. Thank you so much, Paul. And indeed, it's time. In the interest of time, I refrain from any comment, and I would immediately open the Q&A sessions. I can see that there is already a couple of either comments or questions that have been dropped in the Q&A session of the platform. First, from Michael Kubalski. If I understand it correctly, the Polish parliament has recently passed a bill aimed at introducing extrajudicial divorces before the register offices. It is not yet entered into force because it awaits to be signed by the president of the Polish Republic, and this is a useful piece of information for which we are grateful to Mr. Kowalski. Secondly, I can see a question from Duigo Damar Blanken. She basically raises some concerns about including into authorities other than courts, administrative authorities as well, to the extent that they are this way given so they are put basically on a par to the extent, of course, of these principles and the matters covered with judicial functions. So she wonders whether in so doing the principles adhere to the constitutional principle of separation of powers, which of course here on the one hand the judicial power, and on the other hand, say, the administration or the administrative power. I don't know whether either of you wants to take on. I would say the first one is more a comment than a question, but then the second one maybe really should be addressed by either of you.
Well, I can say a few words. First of all, I'm quite grateful to the Polish colleague who informed us about this interesting development in Polish law. Indeed, Poland was included within the 16 jurisdictions, and of course was classified as a system still attached to the judicial competence in matters of divorce, and therefore I'm happy to know, or not happy because I stand for dejudicialization, but of course it is interesting for us. As to the second observation, indeed we are observing, but it is just a general observation that in many fields the distinction between judicial and administrative competence is blurring. Of course, we are one of the aims of the principles is, as I have said, to underline the need that once dejudicializing a matter, a member state should observe or respect certain safeguards. And also to be underlined is that we are dealing in the vast majority of cases of consensual proceedings. We are dealing with agreements. And therefore, in this area, even the judicial competence is quite different from the one the courts have in contentious matters. Paul, yeah.
Exactly. I just wanted to very briefly add something on this as well. I mean, you touched upon this already. Many of the activities that a court carries out are not necessarily judicial functions or functions which in other jurisdictions are carried out by an administration as well. This is highlighted by the case that I mentioned with regard to the preliminary reference. So the Court of Justice held that the German court, so a traditional court issuing certain document or recording certain declarations by the parties, while still being institutionally speaking a court, does not exercise judicial functions. And we also have to take into consideration that within certain legal systems, for example, some of the Scandinavian ones, they have certain activities which are carried out, by example, by municipalities, which, according to the understanding of for example, Germanic or also the Italian legal systems, might not be qualified as independent institutions as being part of the executive, but which, according to the understanding of the Scandinavian or in this case Swedish legal systems, are completely considered to be independent and impartial to the requests brought forward by the citizens. So far we have also in the reports that were carried out within the project, no one addressed the issue of constitutionality for the separation of powers so far, but it's a good point, definitely.
We have just really a handful of minutes, but I was myself thinking and I was wondering whether, with that said, you would apply, say, a clause of fair process of fair procedures to administrative authorities that could be, say, comparable to the fair trial or fair process clause that applies to courts and judicial authorities, whether you think that this is something relevant and whether you have considered this and factored this into the principles in order, again, to somehow, well, address the concerns about the constitutional principles, which is not only a matter of separation between different powers of the state, but it's also a matter of protection of the rights involved insofar as they are parts to the procedure or the process, be it of administrative nature or, say, of judicial nature.
Yes, indeed. Paolo, if you want to say something first, indeed, we considered the procedural rights and of the parties involved in a judicial proceedings, and have tried to adapt them to non-judicial proceedings. This is one of the indeed of the core aims of the project. Paolo?
Yeah, exactly. I think this is part of the minimum standards that were set out in Principle 3. They're very general, or just some indications. So we broke down what we wanted, the very basic elements that should be there. And as Elena already also said, most of these principles, or in most of the jurisdictions, they are already applied already in administrative proceedings, but not only in the administrative proceedings, but also in proceedings involving legal professionals, such as oftentimes it's notaries, but at times there's an additional layer with both parties being represented by a separate lawyer, so that everybody has the required legal knowledge also in order to make an informed decision about, even if it is consensual, but to make an informed decision about a status relationship or so forth. So yeah, we basically try to adapt these principles also to administrative proceedings.
Yeah, this is made by article or principle number 3 with a range of safeguards which range from the need to a personal appearance, the need to be informed, the right to be heard, which regards children and adults involved in a proceeding, and the need that the consent is genuine, that the interests are fairly balanced, that parties are assisted, ideally assisted by or advised by professionals. These are the main safeguards we have recommended.
Thank you so much. This is quite interesting, and it would deserve, of course, much more time and discussion, but eventually we have to wrap up. So first of all, I would like again to praise and to commend the work conducted by Elena, by Paul, by the other co-reporters, and more generally by all the members of the research team and the other bodies carrying out advisory functions and have been involved in the process of drafting these principles, which of course the Institute is committed to further disseminating in other initiatives that will be undertaken. And also I would like again to thank all the participants of these events for their attendance, and particularly Michael Kowalski and Duyago Damar Blanken, who provided their reaction and intervened in the Q&A session. So thank you so much again. Kudos to Elena and Paul, also on behalf of the Institute, and have a nice day. Bye.
Thank you very much.